my privilege to serve as the 10th chair of the board of the Legal Services Corporation and to welcome you not only to this lunch but to events that we're going to be having this afternoon centered on an issue of crucial importance for our country, and that's expanding access to justice. We've had a terrific morning well, first we had scintillating committee meetings. I'm sure a number of you got to experience those. And then we heard from Arcadiana. Where are you folks? Are you right here? And Lakeshore, you guys still here? Lakeshore folks still here? Or did they go back to Michigan? They may have gone back to Michigan. And DNA peoples are right here. From 3 of our grantee programs around the country, across the country. And the impressive work that they're doing. And it's one of the great privileges of being on our board that we get to hear. And this afternoon, you'll have an opportunity at the forum to hear from those in the Mountain States region and how they're collaborating. And immediately following the luncheon, when we go to the forum, we'll be privileged to hear remarks from your distinguished Chief Justice, Matthew Durant, right here. And 2 panel discussions will follow, focusing, as I say, on collaboration in the Mountain States region and then the impact of legal aid in Native American communities. Then following that, we will honor lawyers who provided exceptional pro bono service to our grantee here, Utah Legal Services, at a reception being held at Zions Bank. And at that reception, we'll hear from 4 leaders of the Utah community, Utah legal community, Utah's Bar Foundation President, Lori Nelson. Then the deans of Brigham Young University, Gordon Smith, and the dean of the Quinney College of Law, Dean Warner. And we'll also hear from a partner at the Dorsey Whitney firm, Peggy Hunt. I would like to just take a moment of personal privilege here and acknowledge another leader of the Utah legal community in attendance here today, and that's Justice Tom Lee of the Utah Supreme Court. Well, Tom's father, Rex Lee, happened to be a standout law student at a school that a number of you know well, including, he knows it well too, the University of Chicago Law School. And he happened to have my dad as a teacher, and when my father became U.S. Attorney General in the Ford administration, he was so fortunate that Rex Lee was willing to come join as head of the Civil Division. And I know all of you know here out in Utah how important an individual Rex Lee was to our country. He actually also was very important to my law firm. He founded the Supreme Court practice, and it actually was one of the early Supreme Court practice, maybe the first, in Washington, and we were so privileged to have the benefit of Rex's extraordinary legal mind. So it's been a real pleasure to connect with Justice Lee today, and thank you for being here. And we kick off this afternoon with a very distinguished speaker. She'll be introduced by my colleague on the board, LSC's Abby Kuzma. Abby is one of our 4 new board members sworn in earlier this month. She has served as a non-director member on several of our LSC board committees for some time. She is the Halbrook Distinguished Chair of American Government at Taylor University, where she teaches constitutional law. She co-founded and was the former executive director of Neighborhood Christian Legal Clinic in Indianapolis and served as an assistant attorney general in Indiana. Please welcome our colleague on the LSC board, Abby Kuzma.
Thank you all. It's my privilege to be here, of course, and I have to say, too, I also worked for Orrin Hatch on the Judiciary Committee way back when in the 80s. It was a huge privilege of my life, and Senator Hatch was and is one of my favorite people, so I had to say that as well. It's my pleasure to introduce former Utah Supreme Court Justice Christine Durham. And I want to say that since we've gotten here, we've become aware of how beloved she is in your community. Everyone tells us how excited they are that she is here and going to be speaking. So it's really wonderful to have her with us. She served for 35 years as a justice at the Utah Supreme Court, including 10 years as Chief Justice and a term of President of the Conference of Chief Justices. She previously served on the state trial court after several years in private practice. She is the first woman in Utah to serve as a judge in a court of general jurisdiction and the state's first female Supreme Court justice. Chief Justice Durham has long been active in judicial education. She was a founder of the Leadership Institute in Judicial Education and lead in Utah Coalition for Civic Character and Service Education. She was an adjunct professor for many years at the S.J. Quinney College of Law and at the University of Utah, teaching state constitutional law, and served for 12 years on the Utah Constitutional Revision Commission. She has been recognized nationally for her work and has received honorary degrees from 4 Utah universities. She's also received a number of honors, including in 2007, she received the William H. Rehnquist Award for Judicial Excellence from the National Center for State Courts. This summer, she was honored with the American Bar Association's Robert J. Kutak Award, which the ABA gives to individuals who've made significant contributions to the collaboration of the legal academy, the bench, and the bar. Chief Justice Durham holds a BA from Wesley College and a JD from Duke University, where she's an emeritus member of the Board of Trustees. Please join me in welcoming Chief Justice Durham.
Thank you so much for that kind invitation, and thank you so much to the board and its leadership for inviting me to speak today. I really appreciate this opportunity. I want to talk about something that is a little bit off the beaten track for this audience, but I hope you will find it interesting and relevant to your work. I've been spending quite a bit of time the last little while, partly in preparation for this talk, but also just in some work I'm doing with the project, with your 2017, with LSC's 2017 report on the justice gap. That's a phenomenal report, and all of you new members have now read it and memorized it, right? Absolutely. The only thing is, it's a dispiriting report. The degree to which it documents the gaps in our ability to meet the needs of our citizens in this country at the lower end of the economic scale. It's truly daunting to see how wide the gap is. And I wanted to talk about a project here in Utah that is addressing that gap in a new and different and as yet not clearly contoured way. The State Bar of Utah requested the Utah Supreme Court, how long ago was it, John? 2 years? 2 years ago, John is a past president, John Lund is a past president of the Utah State Bar that was part of that request, requested the court to take a look at our regulatory system with respect to legal services, to see whether there were any ways in which the regulatory system and tweaks or changes or a different approach in that arena could address the justice gap and the access to justice gap. That group determined in its researches that the gap described in the 2017 report was really more like a gulf. And there grew a consensus in their initial research and work that there is no way that the legal profession can volunteer its way out of this crisis with respect to justice. I co-chair the Utah State Bar's Commission on Access to Justice, and I couldn't agree more with that consensus in the sense that For so many years, when I was on the court, I helped with the establishment of pro bono efforts. We have a really quite remarkable online court assistance program working out of the courts. We have a strong committee that works on self-represented litigants and how to meet their needs. We have in Utah, and we've been fortunate over the years to have just an incredible number of legal service entities that work on access to justice issues. But it's one of those battles that the faster you run, the farther behind you feel that you get. So I agree that we can't volunteer ourselves out of the crisis, and that the corporation's research on underfunding, inadequate resources, documents a phenomenon that is true across the nonprofit legal services community. Another consensus is building, or at least emerging. I hope it's getting past the emerging stage and is into the building stage, that there are significant flaws in the structure of the legal profession itself, and that the courts and the regulatory systems that have shaped the justice system for most of our history need to think about rewriting history for the future. Out of this work has emerged a report entitled Narrowing the Access to Justice Gap by Reimagining Regulation. This is by a task force appointed by the Utah Supreme Court. It's the first such report in the country. The state of Arizona, under the direction of the Arizona Supreme Court, just issued a similar report this month, October 4th, and it's quite remarkable the extent to which their recommendations and suggestions and take on what the future might hold correlates and overlaps with ours. So there's possibility that we're on the right track. The state of California has also been very interested in this concern, this set of regulatory problems, and has been working on it. But I was in Los Angeles last week for a conference and met with one of the Court of Appeals judges there who's working on their task force, and she said, "You guys go ahead in Utah. It's going to take us a while to catch up." As you know, California has so many fragmented sources of power and resources that I think it's hard for them to move in arenas like this one, which are so new. So the Utah project looks at ways to revamp regulation to increase access and affordability. The work group's report and recommendations just came out in 2019, and what I'd like to do today is summarize those briefly for you so that you get a better idea of what this is about. The court has universally accepted the report, I understand, and adopted the recommendations. Am I correct in that understanding? I got them from Dino, so I just want to check this horse. Justice Dino Himones was the person who chaired the task force, and he's very much into it. The idea is that a new regulatory structure, which includes broad investments in participation by business entities providing legal services, including non-lawyer investment and ownership, may be of assistance. Now, like many of you in this room, I've been around. I graduated from law school in 1971, and some of what this report is talking about sounds like heresy to me. Nonetheless, I think that might be the problem. That it's time to address the basic bedrock principles that we've operated under, which no longer seem to match up with the marketplace and the needs of the public. So the report basically recommends two concurrent approaches. So two things will be going on at the same time. The first will be largely the work of the court and its committees, will be to substantially relax the restrictions on the corporate practice of law, on lawyer advertising, on solicitation and fee arrangements, including referrals and fee sharing. So that's going to open things up pretty dramatically. And the task force did a really nice job, if you read the report in detail, of doing the research on where these restrictions came from in the first place and what needs they were designed to serve, and highlights the fact that those are not necessarily relevant needs, and therefore the rules are not necessarily relevant. The second thing is to establish a new regulatory body to be called a regulator under the Supreme Court's supervision and direction, but separate and apart from the bar, which, at least in our state, is the regulatory arm for the practice of law. Although all of this will be done, in consultation with and conjunction with the bar, we're looking at a new entity with a new kind of independence. Their job will be this new regulator's job will be to advance and implement a risk-based, evidence-based regulatory process. So if you're going to have a rule or you're going to have a restriction, you're going to have to collect the data to explain why you need that rule and you need that regulation. And at the same time, you're going to have to collect the data to make sure that you're not creating unforeseen risks, especially to consumers, of course, and to the public interest. The report also suggests that the regulator should also solicit new players into the legal service marketplace, including non-traditional providers. Non-lawyers and tech companies might be examples of that, and give them space and opportunities to develop innovative service models and delivery systems. So just for your interest, because you're going to hear this term, and if you're like me, you will have no idea what it's supposed to portray, these spaces are going to be described as regulatory sandboxes. And I guess it comes from the notion that, I once had a trial judge, somebody asked us, what it was like, how much collegiality you had amongst the trial judges. And he said, oh, we don't have any, we all play in our own sandboxes. So I guess this is going to be a similar situation where there's going to be created relaxation of restrictions, and people are going to be vetted. They'll be carefully vetted for entry into this process, but they will then have an opportunity to, with monitoring and evaluation, to try to come up with new approaches to the delivery of legal services that will reduce cost and expand exposure. I just wanted to read a little bit of the language from the report. I mentioned this at the beginning. It talks about how the justice system as a whole, and that includes the courts, has not proved adequate to the relief of the kinds of needs and demands we see in this country. And goes on to say this failure, however, should not be laid at the feet of lawyers. As a profession, lawyers have and continue to give generously of their time and money. But as history has shown, we cannot volunteer or donate the problem away. Likewise, minor tweaks, which while often helpful, are just that, minor. Serious reform requires recognition that our existing regulatory approaches are not working. And they're not working because they aren't risk sensitive on the one hand, really evaluating risk, and market sensitive on the other hand, actually figuring out what the market will bear. Just one more quote from the report. The potential benefits for access to justice from legal disruptions, and make no mistake, this is a major disruption that the court is contemplating in this work, are significant. If legal services can be provided to litigants and those with potential legal problems in a much more cost-effective way, then true access to justice becomes possible for millions of people who currently get no help and are able to do nothing about their problems. Technology, especially online legal services, exponentially increases the potential to improve access to justice. And you know that. Any of you who've got kids under 40, right? Let alone under 30. Where's the first place they go to solve problems? They go online. But it also, technology also simultaneously increases the risk of legal and practical harm to users if the services are not of a sufficient quality. People can get badly hurt by bad service and bad advice. The conclusion of the original task force, which included a lot of people writing and researching in this arena from universities all over the country, particularly Stanford, and an entity down at the University of Denver called the Institute for the Advancement of the American Legal System, which is also doing research and work in this arena. However, the potential benefits are too large to pass up, so changing how legal services are regulated to both open the door to innovation and protect litigants and other users in responsible ways is critical. So that's where we are in Utah. The core policy objectives going forward is going to be to ensure that consumer access to a well-developed, high-quality, innovative, and comprehensive market for legal services happens. It's a very big undertaking. Are all of you, or some of you, aware of the United Kingdom's Legal Reform Act of 2007? You've probably spent some time with it. Because they've launched in a very different regulatory system, but they've launched on a similar reevaluation or regulation in the UK. And one of the things I like to drop in when I'm trying to explain this to people is the fact that in the UK now, today, will writing is no longer a regulated legal activity, as it remains in every state in the United States. Now, does that worry you?
Yes.
Would you take your estate to a non-lawyer to get a will? Maybe relying on an algorithm. The reason the UK abandoned the regulation in this arena is they collected empirical data, and they were able to assess the error rate in wills prepared by both complex and simple wills, prepared by lawyers on the one hand and by non-lawyers on the other. You want to guess? Identical. Identical, 24% error rate. So that startled me, but it took me a ways down the road. So the proposed, I know, this just can't be, can it? The proposed regulator will oversee a limited market, I touched on this earlier, of legal entities approved to participate in the regulatory sandbox that I mentioned. There'll be a controlled environment for piloting and for evaluating new consumer-oriented innovations. So we hope it's going to be a safe environment. They'll be asked to test innovations, to develop business models, and to find out what's possible in terms of new models of service. The evaluation plans for these sandbox participants will be focused on risks, so they'll be collecting data on how consumers fare or will fare under the new systems. And clearly the new sources of data on what kind of regulation works is going to inform the system in very, very interesting and heretofore unseen ways. I mean, I was on the court for 35 years and responsible for regulating the practice of law along with my colleague. I don't recall ever seeing any data on regulatory rules that worked or regulatory rules that didn't work. Even when the bar came to us years ago wanting to do dramatic things with advertising in the form of clamping down on it, they had no data as to who would be hurt by doing so or who would benefit. So that's something we've been missing in our system. And whereas data is now scarce, it clearly needs to be developed. So the report contemplates a 2-year project. Phase 1 is the development of this regulator and the establishment of the sandboxes, and there's currently an expanded task force on which I'm sitting, so I'm drinking from the fire hose like everybody else to try to understand how this might work and what we might undertake for next steps. And then after the original task force envisioned approximately 2 years for phase 1, for figuring out the kind of research and data gathering and regulatory overview part of it. Then in phase 2, the report recommends, and the court by adopting it expresses hope, that some form of independent, nonprofit regulator exercising delegated authority over some or all legal services will be created and emerge. I myself, we're 2 years away from even thinking about that. I have, a lot of questions about where's the money going to come from? How do you maintain the independence when you're raising money, even in the public sector? The nonprofit status will help with the independence, I hope. And that remains to be seen, whether that can be created. Just a note, I mentioned the IAALS, the Institute for the Advancement of the American Legal System. They have announced their intention to try to develop such a regulatory model that could be exported to everybody in the country. So I assume that our group may be working in tandem with their group to some extent to see what they come up with and what might work. So that is a thumbnail sketch of what we're up to in Utah. You may leave Salt Lake City thinking we're crazy. I think there are some, I expect, John, there are even some in the bar who think this is a crazy project. But as someone who's worked sort of at the, as you do, at the nitty-gritty end of access to services where people on the ground simply can, and you know the numbers, you know close to 90% of litigants in court don't have representation, which makes a sham of our adversary system. You can't run an adversary system. And so perhaps one of the things that will happen is to acknowledge that at least in some arenas of the law, we no longer have the capacity to support an adversary system, and we're going to have to come up with lots of other ways to get fair and honest dispute resolution and to make sure that people don't suffer in the ways they suffer now from a lack of access.